All right, let's dive right into episode 10 of our explainer series, Death Squads and Decentralized Futures. Today, we're unpacking some truly monumental shifts in U.S. patent law, and we're exploring exactly how modern creators are actually turning to Web3 to protect their life's work. It is a fascinating journey, looking at how the very concepts of invention and ownership are being radically, completely transformed right now in the 21st century.
Now, this question really anchors our whole deep dive today. Think about it. Does the lone genius inventors still exist, or has the system completely left them behind? For decades, patent theory leaned heavily on this romantic idea of a lone genius in a garage solving problems that stumped all the experts. But today, we're looking at the stark reality for independent creators who are facing these towering legal and technological roadblocks, asking if the system still has their back, or if it's basically evolved to favor massive corporate entities.
So here's our roadmap for this explainer. 1. The lone inventor myth. 2. The 2011 America Invents Act. 3. The Patent Death Squad. And 4. Decentralized Web3 Futures. Let's get into it. Starting with part 1. The lone inventor myth. It's wild to think about, but the very concept of authorship is totally changing. Our sources point out this major shift away from your traditional old-school capitalist framework of publishing and patenting. Instead, we're moving toward a much more decentralized, networked model. The traditional idea of an inventor as a single, perfectly protected owner of a fixed work, well, it's colliding head-on with an internet age that's all about sharing, connections, and participatory production. To understand where we are, we have to look at where we started. For a long, long time, the United States operated under what was called the first to invent standard. This was a highly equitable system. It protected the lone creator, giving them the breathing room, the vital time they needed to perfect their work. They could use lab notebooks, sketch things out, build prototypes, all without needing immediate massive funding. Basically, as long as you could prove you conceived the idea first, your rights were legally locked in. Which brings us to part 2, the 2011 America Invents Act. These dates right here, this is when the playing field fundamentally shifted beneath our feet. In September 2011, the Leigh-Smith America Invents Act, or the AIA, was signed into law. Fast forward to March 2013, and the absolute cornerstone of this act kicked in, the transition to a first inventor-to-file system. We're talking about a massive, structural overhaul of how the U.S. awards patents. The crucial takeaway here is just how stark the contrast is between these two systems. Remember, the old system protected the slow, meticulous inventor by focusing on the conception date. But the new system, first inventor to file, it practically demands a highly capitalized race to the patent office. Honestly, your actual date of conception is now legally irrelevant. Priority goes strictly to whoever manages to file the paperwork first. Now, there are two completely distinct viewpoints on this massive change. From a corporate and international perspective, the World Intellectual Property Organization totally praises this act. They argue it finally aligns the U.S. with the rest of the world. It gives banks, venture capitalists, and investors the kind of transparent stability they desperately need to confidently fund new businesses. But when we look at impartial analysis of that exact same legislation, we see some pretty dire warnings from legal experts and independent creators. Small entities simply cannot afford to compete in a wildly expensive filing race against multinational corporations. This shift effectively stripped those lone creators of the equitable advantage they used to have with low-cost written records. And that leads us right into part 3, the Patent Death Squad. Okay, so the AIA created something called the Patent Trial and Appeal Board, or PTAB. The idea was for it to be an efficient, cost-effective alternative to slogging through federal district court litigation. Its stated goal was to use a mechanism called inter-parties review to basically clear out low-quality or flimsy patents that, just shouldn't have been granted in the first place. Sounds good on paper, right? Well, as our sources detail, the PTAB has become incredibly polarizing. 84%. Just let that number sink in for a second. According to data from the U.S. Inventor Organization, this is the historically staggering rate at which the PTAB has invalidated or canceled at least one challenged claim. Independent inventor associations are arguing that this massive invalidation rate has absolutely devastated the portfolios of countless individual creators, essentially wiping out their property rights entirely. And looking at the recent statistics from fiscal year 2024, it's pretty striking. In final written decisions, 70% found all claims unpatentable, with another 15% ending in a mixed ruling. When you realize that 85% of these trials result in at least one claim being killed off,
It becomes immediately understandable why former Federal Circuit Chief Judge Randall Rader coined the frankly terrifying nickname Patent Death Squad back in 2013.
Now, to be fair, it is important to note that recent patent office leadership has lowered the rate at which these trials are instituted, so there is some relief there. But despite those policy improvements, patent owners who are already trapped in the older pipeline are still facing these tribunals. And critics are quick to point out that these tribunals are frequently led by administrative patent judges who actually have little to no real-world technical experience in the very fields they are judging.
So, what's next? Part 4. Decentralized Web3 Futures.
To escape this increasingly difficult landscape, creators are actively out there exploring a whole new domain of alternative compensation. We're seeing modern patronage through crowdfunding sites, think Kickstarter and Patreon. We're seeing open source sharing via Creative Commons. And most recently, creators are securing digital assets through Web3 blockchain ledgers and NFTs.
Here's how these Web3 alternatives actually work in practice. First, by minting a work on a blockchain, an author establishes absolutely undeniable provenance. And what's truly revolutionary here is that thanks to automated smart contracts, creators can completely bypass the traditional gatekeepers. No publishers, no galleries, no centralized patent offices. This setup allows them to directly monetize their work, potentially retain absolute control of their copyright, and even earn secondary royalties automatically. It's a real game changer. When we put these two models side by side, the evolution is stark. On the one hand, you have the traditional patent system. It's a costly, state-enforced legal monopoly that relies heavily on centralized authorities like the USPTO and the PTAB. And as our sources suggest, right now, that system heavily benefits large, well-capitalized entities. On the other hand, you have Web3, a decentralized, community-driven economy where authority is strictly cryptographic, costs can be significantly lower, and the direct primary beneficiary is the creator themselves. As we wrap up this explainer, I want to leave you with this provocative thought. If modern legislation like the American Invents Act structurally disadvantaged the lone genius, could the decentralized ledgers of Web3 be the ultimate equalizer? It's a fascinating, massive question about the future of human ingenuity and exactly how we as a society choose to reward the minds that build our world. Thank you so much for joining me for this deep dive.